respect of the provisions of Section 144, which has just been read here in court.
Right.
And the reason why I'm standing up, my lord, I will just read subsection 3 only of Section 144, which says, when Attorney General under Section 75, 121 subsection 3, B or 122 subsection 2(1) arraigns an accused for a summary trial in a superior court, the indictment shall be accompanied by a summary of substantial facts of the case that, in the opinion of the Attorney General, are necessary to inform the accused of the allegations against him.
Yes.
So, my lord, my submission is that if the indictment, inclusive of the substantial facts, have been served and read into the record.
Let's keep one thing clear.
Yes, ma'am.
That summary of facts doesn't bind the state. You can't. Am I right, sir?
Yes, indeed. That's what we've placed on.
Yeah, that's
on
what's
on
critical,
record.
because we're reading evidence now. We're including evidence in our argument.
Can I finish?
The charge sheet just says you are charged with murder in that on such and such a day you killed Ratamukwatle. Fine.
My lord,
Okay, go on.
can I finish?
Yeah,
ma'am?
finish.
Thank you. And it says, allegations against him and that which are necessary against him and that will not be prejudicial to the administration of justice,
Yes. Fine, no problem.
or a security of state, as well as list of the witnesses, addresses of the witnesses, and the general and the Attorney General intends calling at the summary of the trial on
Right.
behalf of the state.
Yeah.
My lord, my submission is that as much as the summary of facts and the indictment, it's not binding to the state,
Right.
but it forms part, the substantial facts forms part of the record because they are read into the record. And the purpose of the substantial facts to be read into the record is to inform the accused of the allegations against him or her.
Yeah.
Then my submission, my lord, is that then if on the list of the substantial facts there is a fact in which the
It's a fact or an allegation.
it's an allegation, my lord.
Yes,
Can I just rephrase it?
Yeah.
Yes. There's an
That's it,
allegation.
yeah.
Specifically, wherein it refers to Ms. Kelly Khumalo as a complainant.
Is she a complainant?
My lord, I'm saying as is referred to here in paragraph 5, my lord. My lord, then my submission is that the defense should be allowed to seek clarity to the witness on the issues that appears or on the facts that appears on the substantial facts, my lord.
Okay, fine.
Can we maybe just have
Yeah.
another bite at the cherry? If my colleague is done.
Yeah, it's true. It's true.
Okay. My lord, we just want to raise a point of procedure. My colleagues are at liberty to raise any point, to argue any point. Section 85 was at their disposal to object against the charge sheet. Section 106 was also at their disposal.
Yeah.
Now we're busy with cross-examination, and now legal arguments have been raised in cross-examination. My suggestion, if they have any legal points to raise, they're at liberty to do so, to ask for an adjournment, to formulate such legal arguments. But at this stage, my lord, we submit that we are busy with cross-examination, and we should then focus on the cross-examination. If anyone wants to raise legal points, they may do so, file heads of argument, on which, we'll all respond. That is the
Yeah,
state's
fine.
suggestion.
You know what? I don't want to be accused of being unfair, even if I understand the law differently from what is being argued here about the merits I'm here to decide on the merits. The arguments, I've got to listen to them, fine. The evidence, I've got to listen to it and also thereafter decide whether the state has proven its case beyond a reasonable doubt. But you know what? You can ask this witness anything you want. Mr. Miss, anything you want. Anything.
No, my lord.
I'm talking like you. When you were proposing that there's nothing which you have touched which does not concern the case. So you
Yes.
can ask anything you want about the case. Okay, fine. That's my ruling.
As it is the
Yeah,
court, my
fine.
lord. But again,
No, I've just ruled. Otherwise, we'll be here the whole day.
yes, my lord. But I'm saying I also have to be informed by the fact that whatever I'm asking this witness, even if it is part of the case, it must be relevant.
No.
Yes.
You can ask anything you want of this witness, please. Because
Thank-
when you come to relevancy,
Yes.
then you may have problems, like your learned colleague is saying. He's saying what you're asking is irrelevant because it is the Director of Public Prosecution who formulated that document and took a decision to charge the 5 gentlemen in front of us.
Yes, my lord.
So please, just go on there.
But I think that objection loses sight of the fact that it is very same witness who introduced the notion that this case is prosecutor driven by the Office of the Director of Public Prosecution, my lord. But nonetheless, I realize, Brigadier, thank you. I realize that apparently I'll not be in a position to get the answer to whether or not the Office of the Director of Public Prosecution was privy to the fact that Kelly is a kingpin when they decided to take a decision in this case. That I'm comfortable with. But nonetheless, let us proceed. Now, in terms of your testimony, you are mentioning that it's just a recouping that Kelly is a kingpin, not so.
Ufazini bakho uthi uKelly uyena ohamba phambili ukwenzeni ekudaleni leli cala.
Yes, the evidence, my lord, that we collected suggests that she's a trigger point.
Yebo ufazi sibutholile ibona benza sibone ukuthi konke kusukela kuye.
Now, in terms of your investigation, could you find any motive why Kelly would have wanted to kill Senzo?
La ekuphenyeni kwakho wathola yini ukuthi ngabe kuyisiphi isizathu sokuthi afune ukubulala uSenzo uKelly?
No, my lord, we looked at a number of things. I mean, that is why the court will recall we even read the messages between her and the sister. But to say we found one specific motive, my lord, we've not got that. We are not there yet, my lord. We are still investigating anyway.
Sisaqhubeka nokuphenya angeke ngisho ukuthi ke kukhona isizathu esisodwa singathi isona anaso kodwa ke ziningi izinto esizibhekile sibheke saphinda futhi sabheka nemlayezo eyayithunyelwa phakathi kwakhe nodadewabo kodwa ke angeke ngoba saqhubeka nophenyo asikafinyeleli kulokho.
Thank you, sir. What is prompting all this question is because as I listen to the evidence of the people who were in the house, Madlala, Longetwala, Zandile Twala, Zandile Khumalo, yes, I'm sorry, Zandile Khumalo, basically those are the 3 people who testified were in the house. They said, upon Senzo being, and I'm not here to plead Kelly's case, but they said upon Senzo being shot at, Kelly was very hysterical. She assisted in loading the deceased into the vehicle and she drove like nobody's business. She drove like mad trying to rush the deceased to the hospital. And then something says to me, okay, but then we can interpret Mr.
Manje ke lokhu okushiwa uMadlala noLongethwala noSizande Khumalo kuthiwa ke uKheli wayekhala kakhulu ngesikhathi ke eselinyaziwe uSenzo kuthiwa wasiza ngokuthi asize nokuthi uSenzo afakwe emotweni futhi ke washayela ngesivinini esikhulu.
Now, and at the hospital there, she defied procedures with a view to try that Senzo should be assisted as quick as possible.
Futhi nasesibhedlela ke wafike wacela ukuthi asizwe ngokusheshsha.
Now, something comes to me and say, but the investigating officer keeps on telling this court that, look, Kelly is a trigger point. But what could have been the motive for her to kill Senzo? And again, immediately after Senzo was shot by the bullet, okay?
Futhi ke njoba ke ngizwa lana ukuthi ke umseshi uthi yena uKheli uyena obehamba phambili ekubulaweni kaSenzo. Kodwa ke isizathu ngisitholisisa ukuthi kungabe kuyini isizathu sokuthi afune ukumbulala.
And again, after having been hit or struck by the bullet, Kelly did not waste any time. You know, they bundled the deceased into the motor vehicle and drove at a high speed, that is according to Long, drove at a high speed to the hospital. Is that conduct really compatible with the conduct of a person who wanted another person being killed?
Futhi ke emva kokuthi adutshulweke ngokusho kaLongo ethwala uKheli wazama ukuthi uSenzo Meyiwa afakwe ngokusheshsha emotweni waseshayela ngesikhulu isivini lokho izenzo zomuntu obefisa ukuthi abulawe.
Now do you understand why I wanted to know whether it was the state's narrative from the inception of this case that Kelly Khumalo was the kingpin? Do you now understand?
Ngiyazwisisa ukuthi yini ngithi ke mina bengifuna ukuzwisisa kahle ukuthi yini state uKheli Khumalo uyena ohamba phambili ekuzameni ukuthi ekwenzeni lethal.
So, my lord, I'll start with the last question. As I've said, I cannot speak on behalf of the NPA. I've said it. Decision lies with them insofar as the prosecution, and I can't really, even if I want, I'll be venturing into a terrain where I've got no authority, so I can't take it further than that.
Yes.
Docket was forwarded with all the evidence, including Ms. Kelly Khumalo, and I've indicated that no decision insofar as her position is taken was taken, my lord.
Uqala ngisho ngithi mina angeke ngikwazi ukukhulumela iNPA idocket yadluliswa iswa kubona efaka futhi noKheli Khumalo kodwa ngeke ngikwazi ukubakhulumela abeNPA.
I mean, her position is concerned, my lord. So now, with regard to the naming of Ms. Kelly Khumalo as a kingpin, my lord, the evidence, it is not my assertion. It is not me who stood up and said, now we're going to pursue Ms. Kelly Khumalo. I've indicated way back, my lord, that initially when we started this investigation, it looked like it was a robbery gone wrong. After, obviously, we dissected the docket and concluded that they were intruders. The evidence that was before us at the time when I started the investigation, it looked as if they were intruders, and during the robbery, who were intending to rob, and then things went wrong and the deceased was shot. That's what the evidence was pointing at the time. Fast tracking forward, my lord, getting to accused number 1 and subsequent accused number 2, the picture changed, where for the first time the name of Ms. Kelly Khumalo came in as a trigger point. Now when you investigate, you can't ignore that fact. That is where now the investigation insofar as Ms. Kelly Khumalo comes in, then the exhibit JJ and HH with regard to accused 2 kicks in, and then the name again is mentioned of Ms. Kelly Khumalo as trigger point. Then the investigation goes further and further and further, and all manner of things that I spoke about, my lord, in terms of the links, the cell phone, which I said it could not be. As I was investigating, remember now this allegation is being made. Now I'm trying to find collaboration to say, could this be true or false? And if we found that it was not supported, my lord, yes, we're going to make a finding that this is not true. But then the investigation then revealed in terms of the aspects that we brought in insofar as, for example, cell phone analysis that says, I can establish the link between accused 5 and Ms. Kelly Khumalo with regards to those 2 calls. We've dealt with that. Then he comes in and says, but I can also find the see-through bag between accused 3, the see-through bag that is a common link between accused 3, Ms. Kelly Khumalo in specific because I'm talking to her, and the other links that I'm talking about, my lord. Now, if you take that collectively, and I've also touched base on the issues of the cell phones, which at the time of the offense were not disclosed to the police at the time, because we're now trying to find collaboration, whether there is substance in what was suggested in the confessions. You find all these facts, my lord. You cannot now ignore those things and say, no, it's not true. Evidence that was collected, not my thinking, evidence that was collected supported that there was a trigger point from Ms. Kelly Khumalo, and that's what the evidence said, my lord, emanating from the confessions of both accused number 1 and accused number 2, because that is where the name of Ms. Kelly Khumalo started, not before that.
Engakusho-ke manje ukuthi-ke ukuze sifinyelele lapho esathi khona Kelly Khumalo uyathinteka akuyona into esho yimina, kodwa-ke ekuqaleni kokuzwa ukuthi kukhona ubugebengu obenziwa lapha ngoba khona babezama ukungena bayobamba inkunzi nokuthi kwakukhona abantu abakhona. Eqaleni thina sasibona sengathi yebo kwakubanjwa inkunzi nokuthi kwakukhona-ke ababangenela lapho nokuthi-ke khona uwadutshula lapho. Sasicabanga ukuthi wadutshula ngoba kuwukuthi ngesikhathi bezama ukubamba inkunzi kukhona okungahambanga kahle, kodwa-ke uma sesiqhubekela phambili sesithatha nomfazi womsolo wokuqala nowesibili sesiqhubekela phambili necala, kuyabonakala kuyavela ukuthi hayi bo uKelly ngathi naye uyathinteka khona lapho. And uma sesifaka futhi nembukiso uJJ no-HH kuyabonakala ukuthi cha uKelly ngempela ingathi khona ukusola ukuthi ngabe kuyena ohamba phambili kuleli cala na ukwabe kungelona iqiniso bengeke kube inkinga ukuthi sisheshe sibone nakhona ukuthi hayi lona impela akukho lutho olumhlanganisa naleli cala. Kodwa-ke ekuqhubekeni nokuthi sifune ukuthi sifunisise siye phambili siphenye kwaqala ukubona izinto ezinjengesikhwama lesi esatholakala isiphoma leso okwazi ukubona ngaphakathi kwaso esasibonakala usatholakala efonini kaKelly nasefonini kaMsolo wesithathu. Kona ukwazi uqala ukusenza ukuthi siqala ukubona ukuthi cha khona izinto engathi ziyaxhumana la, and ngeke sikwazi ukuziba ukuthi siyabona ukuthi khona izinto ezibonakalayo la ukuthi hayi uKelly ngathi uyathinteka. And okukhulu nje okwasinika ukuthi sibe nalowo mqondo ukuthi yiloko kwavela ekakhulukazi emafonini kumakhalekhukhwini.
Yes, my lord, I just want to put this into correct context. When I said this is where the name Kelly Khumalo came up, I meant to say when her name was now labeled as a mastermind. That's the right context I want to put it.
No, engifuna ukuchaza ukuthi lavela kanjani la ebengizama ukuchaza ukuthi lavela kanjani ilona igama lakhe njengowayo ungqa phambili kulokhu ekuzameni ukulungisa ukuthi ayodutshula uSenzo.
So in essence, my lord, what I'm saying, you cannot now, as much as I hear what Advocate Mnisi is saying in how it was described, Ms. Kelly Khumalo acted after the incident up to when the deceased was taken to the hospital and whatever transpired at the hospital. After this allegation then came up in the confessions, investigations were done, and this investigation, my lord, revealed what I've tabled before court. And in the search for the truth, I could not, as I'm standing here, I could not find a reasonable explanation or justification as to why, for example, and I'll deal with the calls, what was the relationship between Ms. Kelly Khumalo and accused 5? And what was those calls were about in terms of relations? Because remember, she was a public performer, a singer. It could have been that, for example, they are related, or there was some transactions of some business that they were doing together. I could not find the legitimate reasons for that transaction. I could not, up to today standing here, I could not find reasons as to why there were these similarities in terms of the picture of the money appearing in the photo downloads of accused 3, as well as the one of Ms. Kelly Khumalo, and to be fair, the one of Long as well. I could not find reason, my lord, as to why the phone numbers that were picked up by an expert to say they were existing on that day, because I've explained, my lord, that the issue of the numbers came in when I wanted to establish, because when you follow the confession, it is said one of the accused were constantly talking to Ms. Kelly Khumalo or referring to her as sisters. And I've indicated that, my lord, that when you were looking at the numbers that were known to the state, these two numbers, the one that was alleged to have been robbed, which was robbed and was picked up by Muleleke section, and the one that remained, which was downloaded, we could not find those linkages. We could not find calls that would have come from these accused, except the calls of the 2 of August and the 15th of October on her number that came from accused 5. But the calls of that specific day, on the day of the incident, we could not find. And that then widened the investigation, which then revealed that there were numbers that she was using on that day. And unfortunately, because the police were not aware at the time, could not get those numbers, and that link could not be established, my lord. When we came to know about them, the window period, as I've said, my lord, had passed, and we could not get the actual handset to actually do the download. Now, if you take these facts that I've just mentioned, my lord, or these that were revealed by the investigation, you cannot ignore the fact that there is something untoward, and that is why I then made the application for the J50 in terms of section 43 for Ms. Kelly Khumalo to be added as one of the accused, my lord.
Yebo, ngikuzwile ukube kukhulunywa ubaba umnisi ukuthi ke uKelly Khumalo waziphatha kanjani ngesikhathi uSenzo Meyiwa eyiswa sibhedlela. Ngiyakuzwa lokho. Kodwa ke khona into engesakwazi ukuyiziba ufakazi esihlangana nabo. Mina vele bengakwazi ukuthi ngithi ngingayithola ukuhlobana kukaKelly nomsola wesihlanu, ngoba mhlambe ke asazi mhlambe babe yihlobo o mhlambe babazana ngebhizinisi. Kufika namhlanje angakwazi ukuthi ngitholisise lokho. Kodwa ke ukuthi kwakukhona isithombe esifana nayo esisefonini kaLongo ethwala umsolo wesithathu noKelly, asingeke sikuzibe lokho. Futhi ke nokuthi ke umsolo wesithubili waletha i-confession and nokuthi ke futhi ke la eqoqeni abasola babebiza uKelly Khumalo ukuthi sisters. Ngiyabonana ngathi khona ukuthi ngathi bayamazi, kodwa akazange sithole mhlambe ke amafoni aye ababeqhubana ngawo, kodwa kwaba khona amabili nje, umhla 2 August nomhla 15 October. And lapho ke ekhuluma khona nomsola wesihlanu, kodwa ngokubona ke kunjalo sabona ukuthi kungcono senabise uphenyo lwethu sizama ukutholisisa ukuthi ngaba kunani futhi olunye lungasisiza. Kodwa ke inamba ezazikhona sasingakwazi ukuthi singasebenzisa ngoba sasingenabo makhala ekhukhwini la bese singakwazi ukuthi singenza ama download bona ukuthi sithole ulwazi olungasisiza ukuthi siqhubekisele phambili uphenyo lwethu.
Yes, my lord.
Thank you, Brother. Now you mentioned that you could not find any reason why the same photos which were in accused number 3's, which were downloaded from accused number 3's phone, could be in Kelly's phone. You could not find a reason for that. That's what it just said.
Uthe wena anzani ukwazi ukuthola isizathu sokuthi yini indaba izithombe ezikwazi ukutholakala efonini kaMsolo wesithathu zaphinde zabona zisefonini kaKelly Khumalo.
Yes, my lord, but I'm referring to that in the context of the reasonable explanation. For example, let's say a similar picture is found between me and my colleagues who works with me. The reason could be that we've exchanged it, we've sent each other because we work together. I'm referring a reason in that context that I could not find a reasonable explanation in the course of the investigation as to why there will be these common features that are appearing, the links that the experts are referring to, my lord. I could not find, in other words, a reasonable explanation in terms of any relations between Ms. Kelly Khumalo and accused 3, as we are speaking about accused 3, my lord, there is no relationship that I found, whether in terms of her profession or his whereabouts, in terms of where he come from, homeland, phosphorus. I could not find anything that ties or indicates that these people know each other, and because of that, they could have shared certain things, my lord.
Ukuthi ke phela mina asizange sikwazi ukuthola ukuthi yini umsolo wesithathu enezithombe esifananayo nezithombe esefonini kaKheli ngoba yabona makuukuthi asithi ke mina kukhona izithombe ezisefonini yami nezomuntu esebenzisana nayo kukhona ke into engaba isizathu ukuthi basebenza ndawonye kungaba nesizathu sokuthi mhlambe kukhona izinto ebezingaba semafonini abo bomabili kodwa ke lana sizange sithole sizathu sokuthi umsolo wesithathu noKheli kanti bahlanganaphi bayihlobo mhlambe umsebenzini kukhona into esingathi yabaqhumi futhi nokuthi uhlalaphi umsolo wesithathu akuzange kutholakale lutho nje olwenza ukuthi sithi kukhona ukuxhumana esingathi kungaba khona ngaleso sikhathi.
Yes, my lord.
Thank you, Brigadier. So, in your quest to try and find a reasonable explanation on your narrative, now, did you ever consider what I referred to you yesterday as a scientific invention being a boon to mankind?
Futhi ke wake wathola mhlambe incazelo yaloko ukuthi scientific inventions is a boon to mankind.
No, my lord. I mean, in fairness to Mr. Minister, no, I did not. But that's not how you investigate. You investigate and rely in the search for the truth. You do your best to find the truth, and with greatest respect, not assumption, because I would have assumed. I did not find. Remember, in this matter, my lord, I brought in experts from who works with cell phones. Now, if that was available for some reason or the other, I suppose then the expert would have said, no, this is the explanation as to why this see-through bag is found in these 3 phones. That's not what was informed, that's not the report I got from them. And I relied on that in moving on with the investigation. That's why I'm saying, other than that, me in the course of my investigation, I could not establish link beyond that as to why there will be this link, let me put it that way, not communication, link. Hence, as I've said, I did not find any relations between Ms. Khumalo and accused 3.
Yeah, what emsenzini wethu sifanele sizame ukuthi sithole iqiniso, sifune iqiniso. Singathathi nje esicabangelayo ngoba njengoba bengishilo mina ngasebenzisa uchwepheshe la abochwepheshe bamafoni and futhi ke nabo bathi mabebheka la emafonini abazange banginike ukuthi kukhona enisizathu abanganginika sona esikhomba ukuthi bafanele baqhumene kanjani umsolo noKheli and futhi akuzange kube nesizathu esingathi singinikwa sona esamkelekayo kimi.
That's my answer, my lord.
Thank you, Brigadier. Let's proceed. Now, you had made a number of affidavits. In other words, you have penned a number of affidavits in this case, others with a view to request for certain information, to be allowed to access certain information, the 205 application, the one is known as the 205 applications. Also penned affidavits when you were applying for the warrant of arrest of this accused, not so?
That is correct, my lord.
I think affidavit amaningi lana phakathi kwawo kwakhona nalawo awayecelo zokuthi ukwazi ukuthi ke ufinyelele ulwazi oluthize into enjengamhlambe ke asithi isibonelo lapho ucela ukuthi ufaka izicelo zokuthola ama 205 and okunye ke ilawo ucela khona ukuthi ke ukwazi ukuthi uthole ama warrant of arrest kusho ukuthi incwadi esigunyaza ukuboshwa kwabantu athi yebo kunjani.
Thank you. And the basis of those affidavits will be found in the context of investigation also.
Kusho ukuthi izathu zokuthi ufunela ubhalela ama affidavit kuyatholakala lapho ekuqhubekeni nokuphenya kunjani.
Yes, my lord.
Yebo kunjani.
Thank you. Let us go down the trip memory lane and deal with each of those affidavits that you penned. Now, I'll just give you this paper that I have, just for you to confirm in a general term that these are your statements and everything. You see, I take it. It will be fallacious for me to be expected to say, is that your handwriting? Read back to you, I did everything and everything to you, in terms of what the protocol relating to authentication of statements are. Let us just do it in a very intelligent way. I propose, I'm going to hand to you a document which is supposedly your affidavit. Just have a look at it and confirm whether this is your affidavit.
So nika ke affidavit ngicela ukuthi uyibheke usho ukuthi eyakho yini.
The first document is labeled A333. There it is, say. Yeah. A333. A333. No, don't read my markings. Just
No. I wanted to read. This is the part with my statement, so
Okay,
I want to
fine.
read the contents and understand if I make
You can be rest assured I'm not asking those questions that you see being marked.
No. I just wanted to check the contents of it, my lord. Yes, it is my signature, my lord, and those are my details, my lord.
Thank you.
Okay, yebo imina engiyesayinile lapho and futhi ke nemininingwane lapho iyami.
Thank you. Thank you, sir. Thank you. Now, this is a affidavit that was written to support an application that was directed to the magistrate to authorize an application in terms of Section 205. Do you still remember that?
Yes, I remember, my lord.
Sasifanele sicele sikhase isicelo sokufaka Section 205.
Now, I am just wondering whether I need to read the whole document out or should I just dwell on the portion that I would want us to deal about, or it will be argued that I am ambushing you if I do not read the whole document so that you know the background of the document before I deal with those portions that I would want us to concentrate on. May I request the guidance from the court, madam?
No, I can't advise you. He just told me that you're not going to authenticate the document in terms of the law prescribes you.
I never said that, madam.
I understood you to mean that.
Thank you, madam. Gininda,
Yes.
do you recognize this document?
Yes,
The document lesibhekile.
yes, I do, my lord.
Yebo ngiyayazi.
Do you confirm that this document was written by you?
Uyaqinisekisa ukuthi ke le document yabhalwa wuwe?
It was typed and signed by me, my lord.
Yebo, i-typo yaphinde yasayinwa yimina.
And do you confirm the correctness of the contents of this document?
Ukuthi ke qinisekisa ukuthi konke kubhaleke kahle ngaphakathi kwale document.
Well, my lord, I'll confirm that it is my signature, but remember now here, my lord, it refers to numbers, for example, of the accused. So I don't have the profiling to refer them to you, but it is me, and I'll assume what I wrote here is correct because I'm the investigating officer, my lord.
Yebo, ngizothatha ngokuthi ke imina engayibhala ngoba phela kukhona ezinye izinto ekufanele ukukhulunywa ngazo nezinamba la ngaphakathi.
No, Brigadier. It doesn't work like that. You just heard the court that if I do not properly authenticate this document, then it's going to be considered as a pro non scripto. So I want you to say, with a straight face and say, yeah, no, this is my document. It was penned by me. I stand by the information that is contained in the document. It was commissioned before me, and that is my signature. Otherwise, we will be moving in a. I don't want to be moving on a slippery slope, so to speak.
Angifundisa ngendlela eshibulikayo.
My lord, I agree. This is my statement. I've signed. It was commissioned by me. It was commissioned before me by my colleague. What I'm saying is that the statement refers to certain numbers,
Yes.
and obviously I don't have the profiling to compare if these numbers are accurate. But I confirm it is my statement. It was signed and it was commissioned, my lord.
Ngiyavuma ukuthi statement esami sasayinwa yimina. Ngiyavuma ukuthi sa-commissionwa omunye engisenza naye. Kodwa ke inamba la ama-profile lezinamba angikwazi ukuqinisekisa ngawo.
Now that you are saying you are not able to confirm those numbers, how do you then advise that we cross that bridge? Because I want to go into the statement, but because you are saying you're not sure about those numbers, how should we then cross that bridge? Because I don't want later on to come and argue here, with a limping leg.
Manje ke sizokwazi ukuqhubeka kanjani ke nalezo inamba uma ukuthi awusiqinisekisi.
Probably we need to give you an opportunity to go through those numbers and confirm them.
No, my lord, we can proceed. I confirm this is my statement. I signed it. All I was saying, and I'm saying this, I think with fairness, Advocate Lizzie can understand. I do not have a recollection of these numbers vividly to say this number I got it from here, this number I got it from here, because these numbers would have come from profile, because there's a list of cell phone numbers. But I'm not distancing myself from this statement because I signed it and it's commissioned, my lord.
Singakwazi ukuqhubeka kodwa ke ngizama ukuchaza ngalezi number ukuthi phela angisakhumbuli kahle ukuthi ngizothi le number lena ngayithala la, le number lena ngayithola la, number ngayithola la. Ngibone ngifuna ukuveza.
Now, I'm also trying to think about the best way of doing it, whether I need to make copy available to the court so that as we proceed with the statement, the court is also able to follow what is it that we're speaking about and what paragraph are we. Which is the best way? Thank you. I'm informed by my colleague here that I'm advised by my colleague that we can just go through the paragraphs. Thank you. No, just a minute, madam, because I don't actually want to continue reading, and the court is not in a position to decipher where am I now reading. So, which is the reason why I'm trying to think in a loud way, the best way of actually to go about.
Was that document not handed up?
No, this one it has not yet. But let me confirm with my colleague. But I don't think so. It has not, my lord. But at the end of it all, after we're done with this document, definitely I'm going to request that it should be handed in, my lord.
It will be handed up.
Yes, my lord.
Okay, fine. I mean, after you have said to this witness, he took an oath when signing that document.
Yes, my lord.
He read it, he understood it, and that oath is binding on his conscience. That's what the law prescribes.
Yes, my lord.
Yeah,
Yes.
so you must put it to him, because next time I'll be excoriated in the Constitutional Court that I let in a document as evidence when it was not properly before me.
As it is the court, my lord. Thank you, my
Is
lord.
that not so, Mr. Norman?
Yes. Thank you, my lord. Now, Brigadier, this document, it's numbered very accurately. I think the first document is written A333 in bracket 1, the second one in bracket 2, the third one in bracket 3. That is just the Ronio form with regard to the application. Now, your affidavit starts in A333 in bracket 4. Do you see that?
Yabona yini ukuthi ke i-affidavit yakho iqala kahle kahle ku A444.
Now, as I'm saying, you made a number of documents, you've penned a number of affidavits of this nature, but now I am on this one that is dated on the 7th of December 2020.
Manje ngisho sengishilo ukuthi kwenze ama-affidavit amaningi lesi kuyona manje ile kamhla ka-7 December 2020.
Yes, my lord.
Thank you. Now, on page number A333 in brackets 4, let us go to paragraph 2. I'll call it paragraph 2, subparagraph 5. 1, 2, 3, 4, 5, yes. Where it starts with the sentence, the witnesses.
I see that, my lord.
Thank you. Now, it reads there, the witnesses stated that one of the suspects was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or a brown jacket or top and a hat. He was shorter in height than the second suspect.
Yes, I see that, my lord.
Yes.
No, I'll give him. He'll read from mine.
Oh, okay, no, thanks.
Uthola lapha ufakazi lana washo ukuthi omunye walabasolwa wayephethe isibhamu ekucatshangelwa ukuthi sasiyivolovolo. Lo msolwa lona wachaza njengomuntu onsundu onamehla amakhulu onama dreadlocks egqoke ukhaki noma ibhantshi eli-brown noma i-top no futhi egqoke nesigqoko kodwa lona ke wayemfishanyana kulo msolwa wesibili.
Thank you. This is the description that you are conveying to the magistrate who had to approve or disapprove this application as being what you got from the witnesses, not so?
That is correct, my lord.
Ajele ngazelo lo wayinika emanji le wathi umufanele ufake lapha wabhala ukuthi ngazelo ukuthi wayinjani lo msolwa wathi yebo kunjani.
Is this all that you got, Brigadier Gininda, about the description that you got from the witnesses who were in the house about the description of this person that you are now conveying to the magistrate?
Ikona konke yini wakuthola kuchazwa ababengikhona endlini mayelana nalabasolwa abathi bababona.
Well, I'm not so sure when you say all, my lord, whether is it all in terms of the statements of the witnesses, then the answer is no, because here I was summarizing. It's my statement summarizing what the witnesses have said. It was a summary, my lord. So you were not quoting the statement of each witness verbatim. It's not. It was my statement making an application and indicating what the witnesses have said. So you summarize, my lord.
cha lokho akuzona izitatimende zaloko okakusho ilaba ufakazi bengitshela konke okuphuma emlonyeni yabo lana mina ngangifika nje kuphela lokho engangikuzwile bekusho.
But the essence of what is contained here, it is contained in the witness statements, my lord, that there were two intruders, one had dreadlocks, one was short, one was tall, the issue of the firearm, some witnesses do mention, that's why I said purporting a firearm to be a revolver, because we know that, we've dealt with this issue of the revolver and the expect, my lord. So it's a summary of what the witnesses who were in the house are saying.
Lokho ke okusho lana ukuthi ke kuyafana naloku kuphuma estatementini za labantu ababenginika azelo ukuthi babenjani abasola estatementini zabo ukuthi ke nje lana kufingqiwe ukuthi ke babe babili nokuthi ke omunye nama dreadlock khona omunye wayemfishane khona wayemude nokuthi futhi ke nalendaba yefolofolo kodwa sesikhulumile ngendaba yefolofolo kodwa lana nje ilento ekuthiwa ngesilungu isamari ukusho ukuthi ukufingqiwe.
Yes, my lord.
Thank you, Brigadier. What did the witness who were in the house say about the skin complexion of this person that you are describing to the magistrate in your affidavit?
Manje bathini ke laba ababesendlini uma bechazela ngebala lalomuntu abambona.
My lord, I've indicated that I think about 3 said dark, the other ones did not mention the color, the complexion, my lord. I think we dealt with that point, my lord.
Bathathu abathi wayemnyama and then beseke abanye abazange baphawule ngebala lana.
There was also a mention of dark brown, my lord. So, but the others did not mention that the first suspect was dark in complexion.
Manje kona nje abathi dark brown kodwa ke laba abanye bazange baliphathe noliphathe bala lana.
Thank you. Now, was it by mistake
Kwakuyiphutha in law
that you decided not to tell the magistrate in your application or in your support of your application that this person that I am describing here, I was told by the witnesses, by 3 of the witnesses, that he had a dark skin. The other one, 3 witnesses said he had a dark skin. 1 witness said he had a dark brown skin, and the others were unable to describe his color. Was it by mistake that you did not include that in your confession? I'm sorry, in your affidavit.
Kwakuyiphutha ukuthi manje uma ufaka lesi sicelo sakho awuzange uyitshele manje ukuthi ke abathathu bathi unebala elimnyama amunye wathi hayi yena udark brown obanye kabangaletha incazelo. Kwakuyiphutha
Please, I'm not sure what we're busy with now, but in any case, the witness says he gives a summary, when making this application to the magistrate. Must he now give such details as counsel would, would like him to have in trying to convey to the magistrate what the identity is all about, just to set out these minute details. We submit, my lord, that this is an unfair question, given the fact that this was just a summary in an application to a magistrate.
Thank you, my lord. It's very interesting, my lord. The objection of the state is based on the fact that it was not necessary for this witness to give those little niggling details about the description of or on the description of this suspect. But now, if you deemed it necessary and relevant to speak about dreadlocks, how could you not have deemed it necessary to speak about his skin color?
Manje mawukuthi ke wabona ku semqoka ukuthi ke ungakhuluma ngama dreadlocks yini eyawenza ukuthi kungabi semqoka nakhona ukuthi ukhulume ngebala.
I'm sorry, that is actually a response to the objection by my colleague. It's not a question to him. It's just like that, my lord. That is my response to him, to the state. I'm not so sure whether should I then proceed with my question.
No, the state is just saying, the witness says it's a summary.
Yes.
So the summary of the facts he wants to convey to the magistrate.
Yes, my lord.
That's what he objecting to. That should he now mention each and every detail, that this guy walked with a limp and he was lisping when I spoke to him. That's why he says it's a summary.
My lord.
Maybe let's read, what's the section? Otherwise we're going to be here the whole day again. It's section 205. Just read it.
I just want to get my from.
Oh, you want your...
No, yeah, I've already took counsel.
So that we appraise ourselves as to the requirements required for the issuing of a warrant.
In section 205.
205, yeah.
Yes. Well, the section reads as follows. And the heading is: a judge, regional court magistrate or magistrate may take evidence as to alleged offense. Subsection 1. A judge of a high court, a regional court magistrate, or a magistrate may, subject to the provisions of subsection 4 and subsection 15 of the Regulation of Interception of Communications and Provision of Communication-Related Information Act number 2002, upon the request of a Director of Public Prosecutions or a public prosecutor authorized thereto in writing by the Director of Public Prosecutions, require the attendance before him or her or any other judge, regional court magistrate or magistrate for examination by the Director of Public Prosecutions or the public prosecutor authorized thereto in writing by the Director of Public Prosecutions of any person who is likely to give material or relevant information as to any alleged offense, whether or not it is known by whom the offense was committed, provided that if such a person furnishes that information to the satisfaction of the Director of Public Prosecutions or public prosecutor consent prior to the date on which he or she is required to appear before a judge, regional court magistrate or magistrate, he or she shall be under no further obligation to appear before a judge, regional court magistrate or magistrate. Then subsection 2 is really not relevant. Subsection 3, the examination of any person under subsection 1 may be conducted in private at any place designated by the judge, regional court magistrate or magistrate. And subsection 4, a person required in terms of subsection 1 to appear before a judge, a regional court magistrate or magistrate for examination, and who refuses or fails to give the information contemplated in subsection 1 shall not be sentenced to imprisonment as contemplated in section 189 unless the judge, regional court magistrate or magistrate concerned, as the case may be, is also of the opinion that furnishing of such information is necessary for the administration of justice or the maintenance of law and order. Those are the provisions of section 205. So in simple terms, to subpoena a person who might have information regarding the commission of an offense.
Is it please the court, my lord? I'm not so sure whether I need to proceed.
Yeah,
where
proceed.
I stop, my lord. Thank you. Now, Brigadier, we are telling the magistrate that may you kindly assist me to get a cell phone records in terms of section 205, because amongst others there's a suspect. I'm investigating a criminal case. There's a suspect that is involved here, who is described by these witnesses who saw him as a black male with big eyes, having dreadlocks, wearing a khaki or brown jacket or a top and a hat. He was shorter in height than the second suspect. Now my question is, why didn't you tell the magistrate from whom we are requesting this endeavor to call Rakesh, that this suspect that is also that was seen by these people had a dark skin, had a dark complexion? Why don't you bring that to the attention of the magistrate?
Please, Malak, we have already raised an objection, but we have just read out section 205. All that the section requires is that the person should have information regarding the commission of an offense. As to this detailed minutiae that my colleague refers to, that is not mentioned in the section.
That is, my lord, that is a very gross misunderstanding of the law. What my colleague has just read now, it has got to do with the person who is being requested to give the information, not what should be contained in the affidavit. This is a directive to the person that what is it that is supposed to do. It's, for instance, in the context of this affidavit, that was directed to Rakesh Ishwaraddin from MTN. Now the investigating officer goes to the magistrate or the presiding officer or the judge and say, can you please order Rakesh to bring this information, because we are investigating, amongst others, a case that involves a person who was described by the witnesses who saw him as a black person, a black male, with big eyes, with dreadlocks. He wore a khaki or a brown jacket or a top and a hat. He was shorter in height than the second suspect. Now my question is, why did he omit to tell the magistrate that the same witnesses who told him that this person was a black male with dreadlocks, wearing khaki, top jacket or hat, he was shorter in height than the second suspect, also had a dark complexion? That's my simple question. Why did he omit to tell the magistrate that?
Yes, my lord. My lord, as I've said, this is a summary. You summarize, that's how Section 205 applications are done. Even when you go for the Section 43 application, you summarize. If you have to include each and every context, I'm not sure how many pages you will write, my lord, because then I'm expected to say, others are saying it's dark, others are saying dark brown, others are contradicting the other ones, others are saying revolver, others, because it's a description of what happened. That's not how you do the application. That's not at least how I know it's done, my lord. This is a summary. It was a summary of what I was bringing to the attention of the magistrate and the reasons thereof. The reasons were the subpoenas of the numbers that were not known to the state when the offense was taking place, and they were subsequently known at the time when I made the application, my lord.
Lana ngizama ukuthi ngiletheke isicelo esifinqiwe ngoba kwenziwa kanjalo akufakwa konke, kufakwa nje into efinqiwe. Ngoba ngifuna ukuthi umagistrate azwisise ukuthi ngicelani, ngoba kwenziwa kanjalo uma kwenziwa isection 205 noma isection 43. Futhi ke isizathu ke sokuthi sasifuna ukuthi sithole ukuthi ngoba kukhona lezi number lezi esathi ngaphambilini sasingakazitholi lezi number kodwa ngalesi sikhathi sesizofaka lesi sicelo sasesinazo yikho ke sasifuna ukuthi sicela ukuthola labo section 205.
And my lord, what perhaps should be noted, because I think maybe we are not on the same page with Advocate Mnisi. This statement was not insofar as accused 3 is concerned. So there's nothing malicious to say one was keeping something away insofar as he is concerned so that the court can make a ruling, for example, in terms of the J50. This was an application for section 205. In fact, his number does not even appear on this application. It was simply a background because you need to tell the magistrate what are the allegations and the reasons why you want to, you want the magistrate to authorize this application, my lord. It's a background, so you summarize. So there was nothing malicious or untoward insofar as accused number 3, because this had nothing to do with him, but it's the background of the case.
Lana futhi kuni engifisa ukuphawula ukuthi lana ke isicelo lesi sasingahambelani nomsolo wesithathu. Lokho nje kwakuzama ukuveza ukuthi kuzwakala ukuthi yini indaba sifaka lesi sicelo ngoba sasifuna nje ukuthi kube nendlela ukuthi sendlalele kahle ukuthi kuzwakale kahle ukuthi yini indaba sifaka lesi sicelo okungaqondene nomsolo wesithathu.
Thank you, Brigadier. You're right. Nothing contained in this document has got to do with accused number 3. All that I'm asking you is why did you not include the description that you got from the witnesses of the skin complexion of this person that you are requesting this, that you are describing to the magistrate in this affidavit? That's all that I want. That's got nothing. I don't know how accused number 3 looks like.
Ngifuna ukwazi ukuthi indaba ungayifaka ngencazelo ukuthi umuntu onjani umsolo wesithathu muletha lesi sicelo ku-magistrate.
My lord, I've answered.
Thank you.
It's a summary. I'm not so sure whether, because I think the term explains itself. When you summarize, you don't take the entire context and put it in a summary. That's exactly what it means. It's bigger, you make it smaller. That's what summary says. So what is initially contained here, on the other hand, when you bring it to a summary, you will not have all the facts. Now I'm getting the question from Advocate Mnisi saying I should have explained as if now we are bringing everything from the top to the summary document. That's not how it's done. When you bring an application, you summarize. You simply give the background and summarize the point that you need to create across and the request that you are bringing before the magistrate, my lord.
Saphinda futhi ngiyasho ukuthi lana besizama ukuletha incazelo efingqiwe ngoba besingafane akudingeki ukuthi silethe isicelo esibhalwe konke ngoba kongeyona inhloso leyo. Ngoba uthatha okukhulu uyakufingqa kube kuncane. Iyona into esizama ukuyenza ukuthi kuzwakale nje ukuthi sikhuluma ngani kodwa ngingasho ukuthi sizofaka yonke imininingwane ekhona mayelana nalesi sicelo esisifakayo.
Thank you, Brigadier. As we proceed, I must just remind you that this is an affidavit. It's not a summary, it's not an application. I'm reading from an affidavit, but nonetheless, let us proceed. Now, on page 333.5, you kick off by saying your affidavit, by saying, it is stated that the suspects fled on foot and the hat which was worn by the shooter was left on the crime scene.
That is correct, my lord. I see that.
Ngicela ngokuthi ke lana abasolwa babaleka bengezinyawo kodwa ke bebaleka isigqoko esasigqokwe omunye wabasolwa sawela phansi.
You further said that the incident took place between, on paragraph 4 of this affidavit, the incident took place between 8:30 and 9 o'clock in the evening, and the deceased was declared dead on arrival at the hospital at 9:15 in the evening. Is that what you're saying?
Uthena isahlalo lesisenze phakathi kwamahora ka 8:30 no-9 wasebusuku nokuthi bafike esibhedlela ngo-9:15 akunjalo?
Yes, my lord, that's what I'm saying. Even the top part of the head being left at the crime scene, it's correct. It's contained in the docket.
Yeah,
The declaration of the deceased, when they were declaring him dead at 21:15, it's in the docket. That is correct, my lord. And the estimation, because this 9:30, and it appears in the numerous times in my statements that is between 20:30 and 2100 hours, because you have to take into account the call in which the first responders receive and when they arrive at the time. So that's how you calculate it. So yes, that's what I've said, and that's what is contained in the docket, my lord.
Yebo unjalo ngoba bafika nasesibhedlela basho ukuthi ushonile ngo-9:15 bathi ukuthi ushonile. Yebo lamahora abenjalo ngoba kwavela ukuthi cha kwakuyizo lezo ikhathi zika 8:30 no-9 wasebusuku.
Now, you go on, you proceed in paragraph number 4. Paragraph number 4, subparagraph 2 thereof says, investigation which resulted in evidence under oath revealed that the victim was murdered in a contractual assassination or hit rather than a robbery or a robbery gone wrong.
La yachaza ukuthi umufi lo wabulawa ngabaqashi ukuthi bombulala nokuthi kwakungekona ukuthi wadubuleka ngesikhathi bezaba ukubamba inkunzi.
Yes, that's what I said, my lord.
Yeah, we're going to shit.
And is this evidence that you had when you applied for this, when you wrote this affidavit in application for in preparation for the 205 application?
Manje lokho awuna ngesikhathi ubhala ke le affidavit ufaka isicelo sika 205.
Indeed, my lord. Yes, I had this application because if you look at the commissioning date, it's dated 2020 December 07. The accused were already arraigned even that time. They already made their first appearance in Boxback.
Yebo kunjalo ngoba uyalibona nosuku olubhaliwe lapha ukuthi abasolwa abasisebeboshiwe sebeyovela enkantolo eBoxback.
So you basically are saying to the magistrate that no, this was a contractual killing. It was actually not a robbery or a robbery gone wrong, as the office of the DPP has mentioned in their summary of substantial facts. Not so.
We're going to rise for the last time on this aspect, and you know we don't want to interfere with Advocate Mrs. cross-examination, but we submit with the greatest of respect that we're splitting hairs here. I think this line of cross-examination, and we say this with the greatest of respect, demonstrate a fundamental misconception of Section 205. Section 205, it's aimed at, actually states on there are two jurisdictional aspects regarding Section 205. Firstly, there has to be evidence that an offense has been committed, and secondly, that the person who's been subpoenaed has got that information. So those are the only two jurisdictional aspects that trigger Section 205, namely that an offense has to be committed, the affidavit says that an offense has been committed, and secondly, that the person, the service provider, is in possession of that information. Cell phone records are required to determine if what in or Section 205 records, cell phone records are needed to determine what role any cell phone communication played. This is not a trial before a magistrate. The magistrate is not required to as it were, he's not a trial of fact. All that the magistrate needs to convince himself are those two jurisdictional aspects, that an offense has been committed and the person from whom the information is required is in possession of that information. that can help to resolve the crime in question. Those are the only requirements of the section. What my learned friend is busy with, my lord, will be absolutely of no help as far as Section 2.5 application is concerned.
Is it please the court, my lord? I'm at no point, not even with a bit of an inch, am I challenging the validity of this Section 205. That is not my aim, and I will never do that. However, it should be borne in mind, my lord, that this Section 205 is based on certain information that the magistrate is being provided with, which information stems from the investigation that is contained in the case docket. Unless my colleague says to me he's not feeling comfortable when I'm raising what is contained in this affidavit, which is accompanying. It's an application. How can I put it? This is an affidavit in support of the application of the Section 205. Unless my colleague is saying that I should not actually question this affidavit because as is, it is as is. But it is not as is, vis-a-vis what this witness testified about in his evidence. Remember, he is the same witness, my lord, who penned this statement, this affidavit under oath, which facts he got from his investigation. So there's therefore nothing wrong with me when I take him through what he presented to the magistrate, which is exclusively based on the nature of his investigation. I'm not challenging the validity of the Section 205.
So what are we about if you're not challenging the validity of the information which was acquired?
Contradictions. I'm about contradictions.
What type of contradictions?
Contradictions that will enable the court later on to decide whether he's a credible witness or not.
Yes, sir.
Yes, my lord.
Yes, let's hear.
Thank you, sir. Now, you are saying in your affidavit that the evidence which you heard under oath revealed that the victim was murdered in a contractual assassination or a hit rather than a robbery which has gone wrong. Now, before you answer, let me complete my questioning. Are you aware that what you have just said here totally contradicts the summary of substantial facts that are contained in the indictment? That you are saying this was a hit when the summary of substantial facts are saying that this is a robbery that went wrong. And in fact, you are saying, sir, it was a hit and not a robbery which has gone wrong. Do you see that?
Well, again, my lord, we want to rise on a different aspect, and we'll find authority to this aspect that the motive for the commission of an offense need not be disclosed by the state in the formulation of the charges. So whatever the motive was for the commission of the offense is irrelevant. If someone has been murdered, what the motive thereof was, my lord, is absolutely irrelevant. The fact of the matter is that murder was committed. We submit, therefore, that what my learned friend is trying to elicit from this witness is it's not in keeping what the law says. It says motive for the commission of an offense is irrelevant.
As it please the court, my lord, again I submit, my lord, there is a dire misunderstanding of the Criminal Law Amendment Act. What is that act now that deals with the minimum sentences? The Criminal Law Amendment Act 105 of 1997, yes. That act is very specific, my lord. And subsequent to that act, so many authorities have come. And if my colleague says that in the indictment you don't need to put a motive, as I'm saying, it's a misunderstanding of the law, my lord, because you need to put in the indictment information that will enable the accused to plead thereto, to enable him to conduct his defense in terms of what the charge sheet says. But nonetheless, my lord, I'm not talking motive here in my cross-examination. I am simply bringing it to the attention of this witness that is he then aware that what he's telling this magistrate, he's saying to the magistrate, look, this was a contractual assassination. He has said he does not know why Kelly would have wanted to kill Senzo because he has not investigated that. But all that he knows is that this was a contractual assassination. But the summary of the substantial facts are saying this is robbery or a robbery which has gone wrong. Now I am saying to you, are you then aware that you're basically negating what the summary of substantial facts contain when you say, no, this was not a robbery or a robbery which has gone wrong, but it was a contractual killing? Is he aware that he basically negates what is contained in the indictment? That's all that I'm asking him. I'm not talking motive. I also don't know why Senzo was killed. He also has said that he does not know why Senzo was killed. Contradictions. Thank you, man.
My lord, I'm not sure. Should I answer? Should I respond? I don't know. My lord, look, if I have to comment, firstly, to say or to make an assertion that this statement A333 contradicts what I've said in my evidence in chief is not correct, because it is in line with what I've said. That's number one.
Sorry, Brigadier. Just to correct, I am not saying it contradicts your evidence in chief. I say it contradicts what is contained in the summary of substantial fact in the indictment, not you.
Oh, I thought it was directed to me.
No,
Okay, all right.
It was not directed to you.
All right, okay,
Yes.
then I misunderstood. My apologies.
Thank you.
Secondly, my lord, the issue of the paragraph, the one that deals with the contractual killing rather than the robbery gone wrong. I think it's in. Just want to find it, my lord. But basically, the paragraph that refers to.
Sorry, Brigadier. I realize that it's almost 1 minute past 1. If you want to go through that, I can request an adjournment. Then we go on lunchtime, and then the
No. Let me just put.
come and respond to it when you come back.
No, let me just put it. Let
Oh,
me
you
just
want
deal
to
with
finish
it. Yeah,
it?
let me
Okay,
just
that's
deal
fine.
with it. It will be
Yes.
short, my lord. What I'm saying, my lord, is that the paragraph that refers to the incident being a hit rather than a robbery gone wrong. I also dealt with it, my lord, when I applied for the warrant of arrest of the accused. On the application for the J50, it is dated 23 August 2020. This is before the warrants were authorized. So it is not a new thing. I've dealt with it right from the beginning, going upwards. I've never kept that part away, and that is because the investigation revealed such evidence. So it is not for me, my lord, to take left when evidence is pointing me to right. That's the second part. And thirdly, and I've said this, my lord, I cannot speak on behalf of the NPA. I think the powers there are clearly separated, and I'm not the one who can answer to that. I can only account to what was contained in the docket and what I presented to the magistrate. Now, if I had went to this magistrate in Johannesburg and presented facts which are different to what is contained in the docket, that would have been a crime, my lord. I could not say when evidence sitting before me indicates that this was a contractual killing, then I say something else. This was based on what is contained on the docket, and I presented these facts as they are. That's the truth, my lord.
Thank you, madam. May I request for an adjournment for lunchtime?